a reference was made to the industrial tribunal, pursuant to the orders of the courts. That order of reference is P6 at page 53. Then, my lord, soon after this reference was
Reply has been filed today.
not, I believe so.
Yes.
Yesterday we gave it.
One
Yes. I gone through it, my lord. Answer it also.
short point is involved.
Yes, sir. No, my lord. As I said, the order of reference was made on 4th of March.
Yes.
Soon thereafter, my lord, annexure P7 at 24/4/24 was filed by the respondent number 1. P7, my lord. It's at page 56 of our compilation.
Yes.
No, my lord. If you look at this application, P7, my lord.
Yes, sir.
Page 56. So, my lord, I want to tell you that if you look at this application, it's as good an application as any lawyer could have drafted and filed. So, obviously, the other side does not need the help of a lawyer or a law-knowing person. No, my lord, you reply is page 58. P8, my lord, page 58, P8.
You can appoint any officer of a same skill or expertise.
Sir, we are trying to show that we are officers.
You can appoint any manager of the same skill.
They have already appeared
We'll hear it.
appointed.
We'll hear it. Yes.
Yes. With the reply, apart from the lecture R1 and R2, which are court orders, we also filed at page 78. It's a part of P7, my lord. Sorry, P8, my lord.
P8.
P8. It's annexure R3 of P8, my lord. Which is Association of Industries and Institutions. And it says that this company has been enrolled as a member of the established union. My lord. So, Lord, we come to the next page, 4. It is running page 79.
Yes.
Which, my lord, the officers of the MP chapter of the Association of Employers are appointed. And in the name of the president, my lord would find the gentleman whom we wanted wanted us to represent us. Members of working committee also. Now these documents were filed, my lord. Based on this, my lord, the other side then filed a application annexure P9 at running page 80, seeking various documents by which she could establish what we are saying is not correct. So, my lord, sign. In particular, we are concerned with para 4.1, then 4.3. These two concern us. Then 4.5. This application was filed, seeking documents. Now, petition in para 5.9 says that we sought time to file a reply, but we are not granted. Para 5.9 is not controverted in the reply of respondent number 1. Given time, We would have filed these documents. There's nothing secret about them. Instead of that, my lord, the Honorable Tribunal chose to pass Order Annexure P2, Para 8. Annexure P2, Para 8, running page 27. This is the operative part of the order. द्वितीय पक्ष की ओर से एसोसिएशन ऑफ उद्योग एवं संस्थान द्वारा दिनांक 16 को पारित प्रस्ताव के आधार पर वरिष्ठ अभिभाषक इसको समिति सदस्य चुने गए, अन्य को माने। लेकिन द्वितीय पक्ष ने एसोसिएशन ऑफ उद्योग और संस्थान के गठन वो द्वितीय पक्ष को प्रस्ताव पारित होने के पूर्व से उसके सदस्य होने के प्रमाण में कोई दस्तावेज प्रस्तुत नहीं किए हैं। इसलिए केवल प्रस्ताव दिनांक 25/8/23 के प्रतिलिपि के आधार पर नहीं कहा जा सकता कि अधिवक्ता श्री सोएंसो एवं उनके एसोसिएट सेवा नियोजक के उक्त एसोसिएशन पदाधिकारी रूप में कार्यरत है। Now, prima facie, we had checked documents which say this. But the Honorable Tribunal says इससे नहीं कहा जा सकता. My lord sees that annexure 4 and R3 precisely say this. And the other side had sought the documents in connection with this. If the tribunal granted us some time, we would have produced those documents. Instead of that, we were non-suited.
Have you filed those documents before this court?
But since they were not before that court and I have come in their petition,
These documents are not on.
my lord would not have permitted us to file new documents here, saying that they are travelled beyond the record. Otherwise, even 2 days
But
time,
if this is their specific ground that these documents you wanted to file and
Yes,
you
Sir.
got time, certainly we can examine the relevancy of those documents.
we'll file it on
Or,
Tuesday. We'll file them on Tuesday. my lord.
you demanded those documents by filing reply.
Your Lordship, first we filed a preliminary rejoinder and then this additional application. Now the tribunal, because it goes by sequence, has realized what is the law. They only referred to section 36(1) and 2, not to 3 and 4. That is a very clear kind of legal provision, considering industrial dispute as a special law,
Yes.
where the employers and workmen have to have an equal kind of this thing, So I'm not a lawyer. I'm not doing this thing.
Madam, you are standing in a court since we are
Yes,
seeing
Your Lordship.
since
We
last
have to,
20-30 years.
because there are hardly any pro bono lawyers now.
You are
We can't be saying to the lawyers now. And it's better that we,
say
accept.
you represent case better than 50% of the law.
That is not true. That is not
We
true.
have seen your performance in the court
Yes.
since I was an advocate and they are
Yes.
eligible for.
No, we also fall short
You
many
have
times.
experience of appearing before Supreme Court also.
Work very hard. We have to work. But now,
How many
I will go by sequence, Your Lordship.
no,
In
but
10
you
minutes.
demanded these
No,
documents.
the tribunal considered that it was not necessary to go through those
If we found that they are court has rejected this resolution, then it is not supported by other
because
documents.
whatever documents they filed,
We will take a next week.
Your Lordship, but just a minute. Let me just go through a few things, One thing is that this case has been on since 2021, when there was a second non-genuine transfer sets, not the mills, as per our workers. And VRS is rejected by 98% workers of our union and 90% of the total workers. Now that has gone to the tribunal, a single bench order and the double bench order which they have annexed. They have not said that they went up to Supreme Court and then Supreme Court endorsed the High Court's order.
Madam.
So, after all this, when it went to the tribunal, just a few minutes, Your Lordship, then on the first date itself, 24th April, as he rightly said, we filed the application under section 36 and 4. I'm giving judgments also.
You are representing association.
I'm representing the union.
Representing
Labor union.
labor union.
Yes, yes.
But you are not workman.
No, I'm the president of the union.
As they are demanding.
Next the authorization.
And workmen there in
No.
company.
So
You are like the same status which they are demanding. Let them file a report.
No, Your Lordship. No, Your Lordship. They are demanding for the practicing advocate. Bar Council Rule 49 itself says all the
I can
things
make a balance between.
that they have to resign from the Bar Council if they are the officer and control the association. Now, after the Aditya Birla name came, the nomenclature of the company Century Textiles and Industries changed, which is done through the certificate 17th September. Then that basis, they are saying that they have the right to pay. And the existing advocates, you always know Girish Patwardhan, Kirti Patwardhan, his daughter, they are claiming that they are, appointed as members of the working committee, management committee, not executive committee, but that is also subject to whether the order is erroneous, whether the order is non-tenable legally. Now that is why I have annexed one, judgment of this Honorable High Court. The Century itself had approached against the tribunal order when they had a fake transfer business first. They had to cancel that business transfer agreement. That was in 2017-18. So this.
Let your reply come to us. We don't have because now you filed a reply.
No. Yesterday we gave them and yesterday.
Don't have copy. We did. Today you filed it is under scanning and let's we come on.
It must have come on
File tomorrow. Sorry.
This thing, Your Lordship, because what happened at 4 o'clock, Your Lordship, the advocate who came to file at 4 o'clock, he was told that the honorable judges were not available. So, Your Lordship.
के लिए तो परमिशन नहीं कल तो फाइल कर सकते हो
कल फाइल किया सर
5 बजे वर्किंग आवर्स के बाद आएंगे तो
नो नॉट एट 4 o'clock, Your Lordship.
कोर्ट के बाद आए थे कोर्ट के बाद आए थे तो
नहीं आफ्टर 30.
Yes, sir.
So they said that today that it can be endorsed.
सेकंड को लगा देते हैं इसको सेकंड या थर्ड आपको एनी कन्वीनियंट एनी डेट कन्वीनियंट
Second.
आप यही कहें आप मैडम बाहर से आ रहे हैं आपके लिए कोई डेट बता दें
No, yeah, she's not an outsider, Miller. She's very much an insider.
Insider, not in the court. So,
Second is
the
convenient.
respondent has filed a reply with the permission of court copy has been supplied to the petitioner
you won't mind third?
Shri Bagadi
You won't mind third also?
Personal convenience, then I don't mind.
And Manjit companies have not.
by annexure P9 an application was filed with the industrial court seeking certain documents before
Personal convenience is not disputed.
document could be filed. The tribunal has passed the interim order rejecting the
I would prefer third, Your Lordship.
grant that the court has passed the final.
And Manjit companies who are made parties in a way unnecessarily, but still, and they should not file separate thing because just delay the tribunal proceedings. They have already filed their decision as to who are the advocates, who are the officers. They have appeared till yesterday, even before on the 20th also. So everything has happened and still they never mentioned to the tribunal that they have filed this, miscellaneous petition.
Let the
And
petition
they are pleading before the tribunal as officers, not the advocates.
The honorable judge should also get a chance to speak also.
Yes. And Manjit companies are not filed in Wakalat now.
rejoinder be filed next week.
Date लगाते हैं सर.
Third will not.
नहीं आप पहले रिप्लाई रिजॉइंडर दे दीजिए फिर उसकी डेट थर्ड को लगा देते
हम सर हम 27 को दे देंगे रिजॉइन.
Sir,
हैं who will receive on your behalf
we will receive. Well, we have filed Wakalat also.
नहीं मतलब somebody must be here to receive
Yes.
27 को दे देंगे.
file on or before
ठीक है,
27
27 को दे.
and list on third.
Pardon? हाँ. Aryan Nahar's group helps us. It's all.
ठीक है
Drafting and all is up.
copy of rejoinder is supplied to Nahar. Presence of other respondents are not required.
नहीं सर नो में नहीं है they will find their own
Parties.
With the consent of party, तुम लिखा दें उसमें कि कल को इस ग्राउंड पे ना रिव्यू आएगी, बिल्कुल नहीं सुना गया.
बिल्कुल ठीक है
Should I submit the set of judgments, Your Lordship? The set of judgments?
नहीं, नहीं,
उसी दिन
सीधे
दीजिए
ले ली. ये 2 and 3 को
All
exam करना है.
proxy litigation, Your Lordship. That is
Big
okay.
controversy involved in this between petitioner and respondent about the presence of service to them is something consumer. Higher to them.
Which date? Your Lordship?
third
Okay.
and reply on 27th
Yes, yes.
hearing on 3rd
And if you want to file response to that, you can file before 3rd.
The other parties have not filed any wakalatnama, so we have not given them a
उनको
copy.
delete कर दिया ना
You are,
अच्छा now they are not in the picture
नहीं, आप इसलिए मैं आपसे
they have made the parties, how can they be deleted without?
नहीं, if their presence is required, then we can direct them to pay the PF for.
Either way.
नहीं, आप बताइए.
Yes.
Their submissions, I will point out the grave mistakes which will
Madam,
prove that it's
yeah.
proxy litigation.
Whether their presence is required in this litigation,
If they are going to file separate miscellaneous petitions as they did earlier, one after another, trying to get the stay for the proceedings which have come before the tribunal for resolution of the conflict under the special law which really resolves.
then meanwhile you serve 2 and 3.
दस्ती कर दे सर
Line cut.
can be served
Because
Issue notice.
whatever orders should be able to them also.
3, what is it? Lawful furnish is permitted to serve 2 and 3 by way of hamdast.
And the tribunal's order is applicable to them. Their officer also has started appearing. Their officers also.
Always pleasure to hear, madam.